All right, good morning, everyone. Thank you for joining us this morning for another presentation as a part of our virtual summer series on immigration work and immigrant rights work here in the Southeast and in Georgia specifically. Today we have Ariel Prado from Innovation Law Labs speaking with us today about the Pro Se workshops that he manages on a monthly basis, helping pro se asylum seekers file for relief. Um, I think Ariel's going to ask folks to introduce themselves, and then once he starts presenting, if you could go on mute, and towards the end, we'll be doing some Q&A. So like I said, my name is Shelly Anand. I am a supervising staff attorney with Tahare Justice Center, and I'm so excited to see so many of you joining us today.
Ooh, thanks so much, Shelley. I would love it if folks could introduce themselves real quickly, and if you could just share your name, if you feel like sharing your pronoun, where you're calling from. So I know a lot of folks are calling from Georgia, but probably all over the place. And then just a little bit about what you're hoping to learn this summer. And maybe I'll go at the end. Oh, and one thing, I don't know if folks can see who else is on the call as they're introducing themselves. Because
Yeah, so
if
feel
they,
free to unmute your video so we can see you, so that we can see you when you introduce yourself.
sweet. And I can't see all of the participants. Maybe if I stop
Yeah, I
sharing.
think when you're presenting, it's hard to see folks. So maybe we can start with the intros and then you can share. So does
Perfect.
anyone want to go first in introducing themselves? I'm in a cold call because I can see your names. Anyone?
I can go first.
Okay.
My name is Ramona Hernandez from Advancing Justice, and I'm glad to be here.
Thanks, Ramona. And let's pass it to Abigail next. Maybe we can go in alphabetical order.
Hi, my name is Abigail. My pronouns are she, her, hers. I'm calling from New York City with Justice in Motion, and just wanting to like broaden my understanding of immigration and how it affects like different areas, especially labor and employment.
Cool.
Thanks. Um, from Abigail, let's go to Ali.
Hi everyone, I'm Allie. I'm calling from the DC area, Maryland side. I'm working with Ariel this summer and just trying to deepen my understanding of what exactly we'll be doing.
Oh, and I think after Ali is Carmen.
Hi, sorry, technical difficulties. Hi, my name is Carmen. I'm with Advancing Justice Atlanta, and I'm here just to keep learning more. So happy to be here.
Thanks, Carmen. I think next is Gabriela or Gabriela.
Oh, her microphone wasn't working.
Oh, okay.
Yeah, so Gabriela is an intern with us at Tahare this summer. She's a 2L of CDB University in New York, and she's been great. She's very interested in the intersection of family law and immigration.
Great. Glad to have you here. Um, it looks like next on the list is Jeff.
Yeah, hi. I'm also with Tahari Atlanta interning, and I'm also interested in immigration and family, and also expanding pathways to higher education through um, immigration status.
Great. Thank you. Next down is, I think, Mara Masters. Give her just give them just a few minutes to, or a few seconds to figure out the mic, and then we might move past you. Is there anything in
Oh,
the
her
chat
mic
from
isn't
Mara?
working either. She's with Catholic Charities, interested in asylum and crimmigration. Awesome. We have a crimmigration presentation tomorrow with Jenny Hernandez, so I hope you can attend that one, Mara.
Cool. Thanks, Mara. Next on the list is Monique.
Hi, everybody. My name is Monique. I'm a summer legal intern with Tahari Justice Center at their Atlanta office, and I'm a rising 2L at Emory Law.
Great. Thanks, Monique.
Monique.
And then we've got Paige.
Sorry. I'm a rising 2L at UGA, so I'm in Athens, Georgia. I'm doing an internship locally in Athens. And yeah, this is my first immigration internship, so really just trying to get a broader understanding.
Awesome.
Cool. Thank you. And then I believe it's Rama is next.
Hi, my name is Rama, she, her. I'm actually here in Atlanta working with the Civil and Immigration Defense Unit. And I'm kind of definitely interested in criminal, and we're interested in criminal law and immigration law.
Great. Great. And then Ramona, I think you've already introduced yourself. Shelly, if you introduced yourself, everybody knows who you are. Yeah. And last is Zoe. Zoe, are you there?
Okay, sorry, my camera just took a moment to activate. My name is Zoe. I use she, her. I'll be a 3L at Northeastern University. I'm calling from El Paso, and I'm working with Southern Poverty Law Center this summer. I'm really excited about access to justice and pro se work, especially in the immigration law world. So really excited for this workshop.
Cool. Really excited to have you on. I'm from Boston, actually, so but we won't go into that. There's other people on the call right now. That doesn't make sense. But cool to have somebody calling in from Boston. Cool. My name's Ariel. I use he, him pronouns. I am calling in from Atlanta. And I work with Innovation Law Lab on collaborative projects that attempt to defend asylum, kind of broadly. More specifically, and for what we'll be talking about on this call are the Defend Asylum clinics or workshops. We haven't really settled on what to call them just yet, so you might hear me go back and forth between the two. And then I guess this summer specifically, I'm hoping to pilot a parole project and to continue working with the folks at Tahare to improve upon the monthly Defend Asylum workshops. So yeah, I'm really excited to be here. I'm kind of at that point in the late morning where I'm like over caffeinated, underhydrated, a little bit kind of moving quickly. So I do have a little guide next to me to try and keep me on track. If it feels like I'm jumping off the tracks, anyone feel free to just like interrupt me and pull me back in. Also, if you have questions as we're going, I mean, I want this to be as useful as possible for y'all. So if you have questions as we're going, do feel free to interrupt me. I prefer being interrupted to speaking for long amounts of time because it makes me feel like I'm actually engaging with people instead of giving a lecture, which is not my cup of tea necessarily. But also, if there are no questions, I'm just going to keep going. And we'll put aside so for folks who don't feel comfortable interrupting a stranger, we will definitely set aside some time at the end for some questions in case there are any. I think with that, I'll get started. Super, super grateful to Shelly for organizing this whole series and to Tahare for hosting. It's really exciting to kind of get to connect with new people who are invested in kind of both immigration justice and kind of more broadly access to justice and legal empowerment. So really appreciate the opportunity to be talking with all of you, and thanks for making that happen, Shelly. Thank you. Okay, let's figure out how to share my screen. And I'll forgive everyone who had problems with their mics if folks will forgive me for any technical problems that might come up along the way. I want to start with a brief overview of the history of asylum law in the US, so that we can begin to give some concrete meaning to this notion of defending asylum. For the purposes of today, we'll start with the 1951 Geneva Convention. This is, and when I say a brief history, I mean like a very brief history, a very condensed history. I'm not a historian, but this is kind of, I think, important context. So for the purpose of today, we'll start with the 1951 Geneva Convention, which offered, in my opinion, an overly complex definition of refugee in the aftermath of World War II. The intent of the convention was to prevent governments from forcing people to return to places where they might face persecution. The US didn't sign on to the 1951 convention, but the US did ratify. I was struggling with whether to say we or the US there. I guess we, as a country, did ratify the 1967 protocol, which expanded the scope of the Geneva Convention to the entire world. In doing so, the US committed to upholding the Geneva Convention and the principles of non-refoulement. So in other words, the US committed to not send refugees to a place where they are at risk of persecution, or to a country which might send them to such a place. Provide refugees with a legal status, including rights such as access to employment, education, and social security, and refrain from punishing refugees for entering the US, and I have this in quotations, illegally. Those are three kind of blanket commitments that the US has made with respect to refugees since 1967. I think that's just kind of important to keep in mind as you're engaging in the work that you're going to be engaging in this summer and beyond, because you're going to see a lot of ways in which the US falls short of keeping up with those international commitments. And there are many examples of the ways that the US has fallen short of those international obligations. But in the past 4 years especially, our asylum system has been repeatedly attacked and intentionally dismantled by an unabashedly racist administration. And so where we've seen the US fall short of those obligations in the past, it's, I think, and I'm kind of new to this struggle. I've been focused on asylum and immigration rights for pretty much the duration of the Trump administration. So like a lot of my kind of historical analysis is shared or kind of received from other folks that I've met in this line of work. But my understanding is that this is in recent history the kind of most direct attacks on our asylum system and the most direct racist attempts to undermine our ability to kind of comply with our commitments. So when we talk about asylum seekers in the United States, we're talking about people from all over the world with a diverse range of experiences, but we're predominantly talking about people fleeing persecution in the global South. And I'm just going to pull up, when I said the overly complex definition of a refugee, this is what I was referring to. I think there's while there is kind of this diverse set of experiences, there are also many shared experiences and some common threads. And so I'm going to, again, briefly go over kind of this question of who is seeking asylum in the United States and where are people coming from. So when we talk about people seeking asylum in the US, we are very, very often talking about people who are fleeing countries that have been destabilized by European and US imperialist tendencies and practices. Many of the people seeking asylum in the United States are from indigenous communities that have survived European colonialism, but US imperialism continues to undermine popular movements for worker protections. And actually a lot of this script was written on International Workers' Day, so you'll see that there's kind of a focus on workers' protections as I'm moving through this, but more generally populist and popular movements throughout the global South, paving the way for multinational corporations to exploit workers and dominate national economies and political discourse. So those destabilized economies in turn force people to move, and the US response to immigration, and especially the immigration of people of color, has been to stigmatize what we call economic migrants as undeserving of the right to move. So we start with this idea that somebody who is moving towards relative stability, that is not a legitimate reason to kind of migrate. We're going to be focused on asylum primarily today, But I think that's just an important thing to recognize, that you go back a few steps, and maybe before somebody is facing persecution, before the instability in a country has become as violent as it maybe now is, we're already kind of starting to stigmatize people for moving from relative instability towards stability, when we play a role, or our country has played a role in generating that instability. Kind of tied into that, there's this continued criminalization of communities of color and working class people in the US, which has meant that Black and brown immigrants are caught up in the US's racist police systems, which in turn funnel immigrants of color into the deportation machine. The mass deportation of young immigrants who have been criminalized and then funneled into that deportation machine to places where they have little to no ties further destabilizes these countries and creates more reasons for people to leave, and more reasons for people to come to the US if they have family here to receive them. So I know I moved through all of that super quickly, but the point I'd like to make is that not only has the US committed to protecting people fleeing persecution, not only do we have international obligations to do so, but the US has played an active role in developing the conditions that have generated refugee crises throughout the global south, throughout the world. So I think it's an understatement to say that we bear some responsibility for many of the current refugee crises around the world, and we bear some responsibility for developing a humane and compassionate response to those refugee crises. I'll pause for a second to see if there are any questions. Maybe I'll just do like a quick down to give people time to unmute their mics. And if there's also, I mean, that was a super kind of, I did not give that history the attention it deserves. And so if there's more that people feel that they need to add to that, please do feel invited. You can use the chat if fumbling with the mic and the camera feels a little bit daunting, or otherwise just feel free to interrupt me, and I'd love to kind of engage on that.
Ariel, in the chat, I do have a book I recommend that gives kind of a great overview of what you were talking about, but mostly just on the history of immigration law and the intersection of labor, and kind of our use of labor from Mexico and the Northern Triangle countries. And we have iterations of that today with the H-2A program and H-2B programs, but really gets to the heart of some of the topics you were talking about. I know this book is required reading for students at Freedom University here in Georgia, which is a university for students that are undocumented. Georgia doesn't allow undocumented kids to go to the top, I think, 3 to 5 universities in Georgia, and they have to pay out-of-state tuition even if they're Georgia residents. So the school was started by some UGA professors, and this is one of the books that they recommend. So I wanted to share that with folks.
Thanks, Shelley. What's the name of the book?
It's called Undocumented by Aviva Chomsky.
I'm just writing that down for myself because I cannot see the chat right this minute. Cool, thank you. Anything else from anyone else? Other books people want to suggest? I guess for now, put it in the chat. I don't think I'm actually going to fill up the full hour, so there will be some time to kind of discuss at the very end as well. But for now, if you have any suggestions for reading materials that you want to share with other folks on this call, or other resources, please feel free to add them, or invited to add them to the chat. So, where I kind of left off was this idea that we do bear some responsibility for developing a compassionate response to the refugee crises that we've had a hand in or the conditions that we've had a hand in developing. And rather than act from a place of responsibility and generosity, what we've seen, and I think what we've all kind of recognized, is that our government has adopted a deterrent strategy. So similarly to the way that we respond as a country to many social problems, we've chosen to punish people rather than trying to understand the kind of the root of the issue. So we punish people for seeking safety and stability, and we continue to exploit them from the moment they arrive in the United States. Folks are locked in detention centers and forced to work for the profit of taxpayer-funded private prison corporations. And if and when they are released, it's difficult to impossible for a person seeking asylum to secure a work permit without legal representation. This doesn't mean people don't work. There are barely any safety nets in place for people seeking asylum, particularly here in Georgia. And folks have to work to survive. Folks have to work to survive, and they have to work to support their children. So what it actually means is that people seeking asylum are hyper vulnerable to exploitation by employers who can wield the call of calling immigration authorities against them if they dare to complain about working conditions. So we hang over their heads the entire time that they're here, even if they stick with the legal process, the threat that our government might forcibly return them to the countries that they left behind. In Georgia, it comes full circle. So Stewart Detention Center, which maybe many of you know, is in Lumpkin, Georgia. Move through the slides try and keep pace with myself. Stewart Detention Center is in Lumpkin, Georgia, and it's less than an hour away from the Western Hemisphere Institute for Security Cooperation, also known as WINSEC, and formerly known as the School of the Americas. The School of the Americas is a program that has trained military forces throughout Central and South America on how to repress popular movements. Some of the tactics that they train people on are how to assassinate leaders of movements. And so asylum seekers who are detained, or really people who are detained at Stewart Detention Center, are being detained within driving distance of the institution that helped create the conditions that have displaced thousands. There's a phrase that you might hear repeated in conversations about migrant justice. It's "estamos aquí porque ustedes estuvieron allá." This idea that we are here because y'all were there. And I think, again, that's just something, as we're talking about this work, that's really important to keep in mind. So all that is meant to be just a bit of context for the work y'all are going to be engaging in this summer. I know for many of you that's probably not new. And maybe many of you have kind of studied it on a level that's considerably deeper than what we've just passed over. And so if you do have resources or materials that you want to share with folks on the call, please don't hesitate to share those, or just reactions if there's more that you want to add to the conversation. The U.S. government's approach to migration, as I said, it's in many ways similar to how our government approaches many social issues. If we punish people badly enough, it'll stop happening. And so I think it's important, even as many of us are engaged in case-by-case direct service provision, to keep in mind that we are responding to and working within that system and within that within our government strategy. One that has prioritized the movement of money and industry over the movement of people, and that has punished people for seeking stability and safety. So, if we're going to challenge that system and work to defend the communities most vulnerable to it, all of the work you're doing this summer is necessary. We have to engage in preventative work. We have to document and challenge the way detention and deportations play out on a case-by-case basis. And we have to demand systemic change. What you're looking at on your screen right now is kind of one way of modeling what a collaborative attempt to do all of that might look like. There's different ways to map the work out. This is kind of something that we Law Lab kind of refer back to just as a way of kind of aligning our programs across the organization. But I think I've seen other ways of mapping the work that work equally well. This is just kind of one way that one could choose to do it. So what we have here are 5 zones, and I can barely read the words on my screen. I'm not sure if y'all can, but I'm just going to kind of quickly go through and describe what the 5 zones are. And actually, we have since added a 6th zone, just kind of right there in the middle. So zone 1 we talk about as prevention and education. It's this idea that there is important preventative work that needs to be done before people have been arrested by ICE, before ICE has kind of gotten involved. And that happens on kind of both sides or multiple sides of the borders, I guess. So we can think about Al Otro Lado in Tijuana, which is informing folks who are arriving and considering presenting themselves at a port of entry as to what they should expect from immigrant detention and from kind of the credible fear process all the way through to the end, with a real focus on kind of the beginning of that process. So informing folks of what what kind of the legal process looks like. But we also have folks who do that kind of within the US as well, working with undocumented communities who might be eligible for affirmative relief or affirmative benefits. And so we think about that kind of as being part of this prevention and education piece, this idea of know your rights, legal orientations beyond know your rights before someone has been targeted by the detention and deportation apparatus. We then move to zone 2, where we have what people describe as rapid response. And so in rapid response, what we're really interested in doing is documenting that point at which ICE first gets involved. So here in Georgia, there's actually a program that the Georgia Latino Alliance for Human Rights has been running for some time and is kind of doubling down on or reinvesting in, called ICE Chasers. And it's this idea that you can have volunteers from the community who will respond when folks in the community call the hotline to say that they have seen ICE engaging in arrests. And so the idea then is that ICE chasers will rush to the scene and film what's going on and do their best to kind of intervene in a lawful manner. Zone 3, we call the critical response period, but really most often there we're talking about work that happens to support people who are in detention. So once somebody has been detained, immigrant detention in many ways serves to expedite the deportation process. Terrible conditions in detention centers kind of convince people to give up on their cases. And so there's this really critical response period where if somebody is willing and able to fight their case, we want to make sure that they have support. And so that critical response period, we're usually focused on getting people out of detention as quickly as possible, if possible. And sometimes that happens and sometimes it doesn't. And either way, if somebody's fighting their case, whether it's from within detention or outside in the community, we kind of move into zone 4, where we're talking about immigrant defense or long-term defense. And the idea there is that we're really focused on the merits, that we're focused on helping somebody defend themselves from a removal order, as opposed to helping someone get out of detention. And so we have zone 4 there. A lot of you are probably doing work in zone 4 this summer, would be in what we describe as zone 4, not to characterize your work for you, but that's how we would kind of describe it. And then zone 5, we have this redress and accountability zone, this idea that this is where everything that's been documented throughout zone 1 through 4, this is where kind of a lot of that information gets synchronized and or synthesized, and where you start to see impact litigation, systematic appellate work, which can also kind of overlap with zone 4, but this idea that we need organizations who are explicitly focused on challenging the system as it currently is. Zone 6 is not really represented here except for as like a little dot in the middle there. And the idea of zone 6 is really that, you know, it's great if we have organizations, powerful and active organizations in each of these zones, but what we really need is to make sure that those organizations, in addition to doing their work, and which, you know, people do, is actually, there's a lot of work that goes into kind of aligning the work that different organizations are doing and kind of pulling all of that work together. So I did not mean to spend as much time on this slide, but this is when I actually didn't develop the script here, and so that's what happens when I go off script. But that's kind of an overview of the way that we think about developing a cohesive response to kind of a white supremacist attack on immigrants. And today we're going to focus on a program in Zone 4. We're going to focus on the Defend Asylum clinics. So I'm going to talk just a little bit about kind of what the impetus was for starting the Defend Asylum clinic, specifically here in Atlanta, what it is that we're aiming to do through the Defend Asylum clinics, and what it is that we actually do, because we're definitely not, I guess, self-actualized is maybe the term. We have not kind of built them out to what we really want them to be yet, and so we're still evolving along that path. Let me see if I should go. Yeah, I'll go back to the script for a minute. Um, so I want to kind of start with the origins of the project, and I'm going to do that first from kind of the story of an individual, and then from the story of like our massive referral list in 2016. So we'll start with Brenda's story. Brenda and her daughter arrived in Tijuana, Mexico, and entered the U.S. to seek asylum. And here it says late January 2018. We can stick with that date. That's fine. So they arrive, and they arrive in Tijuana, and I've already mentioned Al Otro Lado. I mentioned them just because it's an organization along the border that I've worked with in the past. There are other organizations doing similar and really great work kind of along the border. But they meet with Al Otro Lado, they meet with a volunteer, and that volunteer orients Brenda to the asylum process in the United States, to the kind of detention apparatus, and what exactly she should be expecting as she's preparing to turn herself in at the San Isidro port of entry. So by the time Brenda and her daughter are approaching that port of entry, Brenda knows that she's likely to be detained, that she'll very likely receive a credible fear interview, that she's going to have to receive, if she receives a credible fear interview, she'll have to receive a positive decision on that interview in order to be released from detention. And she was warned that she might even be separated from her child. She made the decision, with all of that information, that it was better to take those risks than to continue living in hiding in Tijuana, where the people who wanted to hurt her might find her. And so Brenda turned herself in. She and her daughter were detained in rural Texas. Here it says or Georgia or Oklahoma, but with Brenda specifically, it was actually in rural Texas, in Dilley, Texas, which is a small town about an hour and 20 minutes south and a little bit west of San Antonio, where the South Texas Family Residential Center is. At the South Texas Family Residential Center, there is a program. It used to be called the CARA Project. It is now called the Dilley Pro Bono Project. And when Brenda was detained, in Dilley at the South Texas Family Residential Center, the Dilley Pro Bono Project helped her to prepare for her credible fear interview. And when she received a positive determination on that credible fear interview, they advocated for her to be paroled quickly, so that she could be out of detention with her daughter as soon as possible. So far, Brenda's been relatively lucky. She had someone to orient her to kind of what to expect as she was getting ready to turn herself in at the U.S.-Mexico border. And then once she was in detention, she had access to attorneys, to a legal orientation, to kind of a description, again, of the process as she'd been through it so far. So some demystification of kind of her experiences with Customs and Border Patrol, CBP, and with ICE, and in detention. And then a little bit of kind of an orientation as to what to expect when she got out of detention. Brenda actually, so she was released from detention. She actually traveled first to Houston, and she stayed in Houston for a little bit. And then before her first hearing in Houston, she moved to Atlanta. And as she was moving to Atlanta, a legal service provider in Houston gave her a list of nonprofits that provide pro bono legal representation in Atlanta. And so Brenda arrived in Atlanta, and she started calling those offices. She called every number on the list that she had, but the issue in Atlanta was that, at that time there were even fewer nonprofits than there currently are, or fewer free attorneys, pro bono attorneys than there currently are, and they were all operating at full capacity. That is to say, they had already taken the caseloads that they could afford to take, and they couldn't kind of intake another person, at least not at the time that Brenda called. And so Brenda called every 2 months. She would call again. She'd run down the list, and every 2 months she'd be told, I'm sorry, we've taken the cases we can take for now, but please call back, and we'll try and get you an attorney when we can. At a certain point, Brenda's next court date, it's in Houston. She doesn't have any way of arriving there, and she's past her filing deadline at this point for her asylum application. More than a year has gone by since she entered the U.S., and we'll talk about it in just a minute, but there's a filing deadline for asylum applications, and not having filed before that deadline significantly kind of complicates the asylum process. So that's where Brenda is, actually, before we jump to harm reduction. And her situation is fairly common. In 2016, we had a list of folks who were leaving the Dilley Detention Center, the South Texas Family Residential Center, of several hundred folks who had left Dilley and had come to Atlanta. And as an organization, what we were trying to do, what LALAB was doing in kind of collaboration with other organizations here in Atlanta, was looking for pro bono attorneys who could provide full representation to everyone on that list. And what we found was that, so initially at that time, cases were moving really quickly. We'll talk about, actually, let me just pull up a case timeline real quick. So when I say cases were moving really quickly, you can see here, I don't know if you can see my cursor on the screen, but I'm kind of hovering around this individual hearing. So before the individual hearing, there's kind of two types of hearings in removal proceedings, generally speaking. There are master calendar hearings and there are individual hearings. Master calendar hearings are procedural in nature. The idea is that that is where a judge is supposed to explain to an individual, especially if that individual is appearing pro se, the nature of the hearings, what is at stake, what their rights are in the proceedings, and then help the person to think through what forms of relief they might be eligible for. An individual hearing is actually the kind of evidentiary hearing. It's the point at which the person in removal proceedings gets to present their evidence to the judge, gets to state their case and kind of explain why it is that they should be, why they merit relief from deportation. Why did I bring this up? What was I talking about just before? I guess I can't really ask you all that. This is why it's good to stay on script. I got it. From master calendar to merits hearing. That's what I was talking about. So when we started placing cases in 2016, from master calendar to merits hearing, we were seeing about 45 days. So cases were moving really quickly, is what that means. If you placed a case with an attorney, that attorney would work on the case. The cases were actually moving a little too quickly. It was very hard to prepare a case on such a short timeline, and so the thought was that we could kind of cycle through this referral list, place a case, let the attorney argue it, and then place the next case. And pretty soon after we started placing those cases, we started seeing kind of these indefinite postponements. We started seeing asylum seekers who had attorneys, their merits hearings would get kicked back from, December of 2016 to December of 2018, and then again kicked back another 2 years. And so we still are supporting some attorneys who took cases back in 2016, and those cases haven't gone to merits yet. And the result was that we had this list of like 200 people who were all in removal proceedings, who were all at risk of removal orders, and about 20, maybe 30 attorneys that we could kind of call on to try and represent them all for free. And so those attorneys, some would take one case, some would take two cases, some of the like real rock stars took 3, maybe 4 cases. But very few attorneys were willing to take more than 4 cases at a time. And those cases weren't moving forward. And so we couldn't place additional cases with folks. And we ended up, we placed maybe the first 30 cases in that list, but we still had several hundred folks who we were tracking their cases, and we were watching them kind of move along this timeline that I'll explain in just a minute, and watching them lose their cases for procedural reasons. Watching folks lose because they didn't turn in their application for relief when a judge ordered them to at a master calendar hearing or before their 1-year filing deadline. Watching folks who maybe did manage to submit an application for relief but didn't know how to apply for a work permit, and so they never had a chance to kind of work lawfully throughout this entire process, which left them open to exploitation. Or watching people who just didn't know how to track when their next hearing dates were, and so missing hearings. And if you don't show up for a hearing, even if it's a kind of logistical procedural hearing of the master calendar, it is more than likely that you're going to be ordered removed or deported. So in Brenda's case, Brenda was one of the very first people to participate in the Defend Asylum clinics. And it was really her advocating for herself. We had kind of explained to her, okay, well, we can't find you an attorney, but you need to find an attorney because if you don't find an attorney, these are the kind of upcoming deadlines. These are the ways that you might lose your case. And Brenda just kept calling and saying, like, there are no attorneys, and I don't want to lose my case for one of these ridiculous reasons that you've described to me. Like, just help me with that piece. And I think she was right. I mean, there was no reason that we couldn't just help her with kind of the next piece of the puzzle. So Brenda knew that she couldn't get to Houston, but she had a hearing in Houston. And she also knew that she could change venue from Houston to Atlanta, but she didn't know how to do that. And so we found a volunteer who could walk her through that process. Brenda knew that she needed to submit an I-589, that she was actually past her one-year filing deadline. And so through the Defend Asylum clinics, we were also able to help her with that piece. And now actually, so the I-765, I'll take a step back. I-589 is an application for asylum for folks who don't know. All of these forms you can Google very quickly and kind of figure out what they are. The I-765 is an application for an employment authorization document. And at this point, Brenda has actually submitted her I-589. 150 days went by, so she became EAD eligible or eligible for a work permit. She submitted her application for a work permit, and she is now working lawfully while she waits for her merits hearing. And she kind of, I guess, indirectly helped to design the workshops as they currently exist. And so the clinics that I'm kind of describing in a very roundabout way today are really about harm reduction. We don't want people to be losing their cases, people who are kind of at risk of imminent removal orders for procedural reasons. We don't want them to lose for procedural reasons. We want them at least to be able to safeguard their right to an evidentiary hearing, to set a record, and to then appeal the decision of the judge. So these are some of the kind of services that we offer at the clinics, and we'll go into those in more depth in just a minute. I think I actually am going to take up the full hour, which I was not expecting, so I'll try and speed up just a little bit. Okay, I do want to go through this timeline. So we talked about kind of Brenda's case. She entered the U.S. at San Isidro. Brenda was detained, and so she did have a fear interview. And I can send this slideshow to folks if they want to kind of read through these descriptions in more detail. After her fear interview, she received a positive decision, which meant that she received a notice to appear. This is really distracting in this moment because there's a proposed change to the regulations, which would actually mean that somebody who receives a positive fear decision would not be put into 240 proceedings, would not receive kind of the notice to appear as historically folks have. So I'm going to continue along this timeline as if this proposal didn't exist, but it's extremely scary. And I don't know of a great analysis, Shelley. I don't know if you have any kind of breakdown of the proposal somewhere that maybe we could share in the chat, and if not,
yeah, I can. I'm happy to share. I mean, I think a lot of people are like, I know our policy team is still processing it, and they've just opened it up to comments today, I think. But I will share some of the kind of proposed changes. But it's really just codifying some really terrible decisions that the Attorney General has made. It's very rare in past administrations the Attorney General does have a power to adjudicate appeals that have gone to the BIA, but it hasn't been done in any other administration as frequently as it was done or has been done in this administration. And so case law or like precedent-setting law that the AGs have done, like in matter of AB, for example, which is the bread and butter of what we do at Tahrir, which is domestic violence-based asylum. Jeff Sessions reached in, pulled it, and said, no, it's going to be much harder to do that. And to add, not only is there precedent there, and the courts are now applying Chevron deference to his decision there. Now it's going to be put into regulations. So just making that battle even more difficult. And so it's going to be a difficult moment for us practitioners if these come to pass. So I will send in the link some of the information. I can also send you guys some really great immigration attorneys that I follow on Twitter that are just constantly talking about this stuff and giving really great analysis. So I'll share that momentarily.
That sounds great. Thanks, Shelley. And I think that's one of the things, like we developed this timeline. We actually first developed this timeline in Spanish because it's a tool for folks who are in this process to kind of understand what the timeline looks like, what the process looks like. And one of the things that's so challenging about working under this administration is that they are constantly attacking the system, undermining the process. The process is already rigged, and especially in Atlanta, and we'll get into that if there's time. But this process is actually kind of, there is a good chance that this process becomes even more rigged based on this proposal that came out yesterday. In Brenda's case, though, which moved forward before the proposal came out, she got a positive credible fear interview decision. She received a notice to appear, which meant that her case kind of moved from expedited removal, or 235B, into 240 proceedings before an immigration judge, and she was released from detention. She has this filing deadline, which is typically a 1-year filing deadline. So upon entering the country, a clock kind of starts ticking, and once somebody has been in the U.S. for a year, they are supposed to have submitted their asylum application. It can be moved up by an immigration judge. So if you have a hearing and the immigration judge says at your next hearing you need to submit your asylum application, then not doing so can result in the judge deciding that you have abandoned your claim for relief and ordering you removed at that moment. But typically speaking, it's about a year into the process, unless there's some kind of priority docket that's been implemented. Once somebody has submitted their asylum application, after 150 days, they can apply for work authorization. After 180 days, they can receive that work authorization, although usually it takes a little bit longer than 30 days to adjudicate the application. And once somebody has submitted the asylum application, the judge should, upon reviewing and accepting the application, set a date for an individual hearing or merits hearing. In Atlanta, what we've seen, and I'm going to try and condense the end of this because I didn't realize how much I talk. In Atlanta, what we've seen is that judges deny all asylum claims. So we kind of have included on this timeline, because it's what we anticipate, everyone is going to have to appeal. If they want to continue with their case, is going to have to appeal the decision of the immigration judge. And so 30 days after the judge has made their decision, that's the deadline for filing the appeal. So through the workshops, we try and intervene at kind of these 3 points now. And actually there's a 4th point here, which we're kind of continuing to develop in partnership with Tahare. Leading up to the filing deadline, we have these 3 points of intervention. So these are all with respect to kind of completing an asylum application. We'll then help somebody once they're eligible to apply for work authorization. So that's what this 4th arrow represents. And then the 5th arrow is kind of still in development, still in process. We're doing it on a little bit more of an ad hoc basis based on the questions that people have as they're going into their individual hearings, but it's something that we'd like to kind of systematize going forward, is a merits hearing prep. So, what is the information that people need in order to be able to prepare to testify before the immigration judge. And then the 6th arrow, which you don't see here, is referenced as kind of one of the means of harm reduction, which is the E26, which is a notice of appeal. And then there's also the E26A, which is a fee waiver, although more and more of those are getting rejected. So we'll also help, once somebody has received a negative decision from the judge, we'll also help them appeal that decision. I think the name of this presentation was supposed to be legal empowerment. So I don't even know that we've necessarily touched on that topic yet. There's a definition that I really like of legal empowerment provided by a group called Justice Power. I think you can find them at justicepower.org. And what they say is that legal empowerment is a process by which individuals and communities tackle injustice by knowing, using, and shaping the laws that impact their lives. So that is really kind of the goal of the workshops. We want to make sure that people know the kind of legal process that they're and the law within which they're operating, that people know how to use that in conjunction with kind of trained volunteers. We don't, it's not that everyone has to become an expert on asylum law in order to win their asylum case, but having a basic understanding of it allows people to then work with a volunteer to move through the process in a way that makes sense for their case timeline. And then the last piece is shaping the laws. And I don't think, I mean, we most certainly have not gotten to a point where folks who are participating in the workshops are empowered enough or in a position to, or organized enough really to shape the laws that instead we're having to navigate. But that would be kind of the eventual goal. So I want to start with knowing the laws, and we might not get much past that today. Okay. The 1980, actually, and I'm going to try and get through this in 4 minutes so that we can leave 5 minutes for questions. Does that make sense? Cool. The 1980 Refugee Act, I've already kind of complained about the fact that the definition of a refugee, and actually this predates the 1980 Refugee Act, is overly complex. I have it up on the screen here. Without going, I mean, judges disagree on this in different jurisdictions. What a particular social group is kind of wildly differs in different circuits. Different attorneys have different interpretations of this. Many attorneys feel that they don't understand kind of what this definition puts forth. And so when we talk about legal empowerment, kind of the first step being to know the law, that's why I say that this is overly complex, because in order to win asylum, a person has to prove that they fit this definition. And if we can't even, if judges can't even come to a consensus as to what this definition means or what these words mean, then it seems totally unreasonable to me that we might expect someone who is fleeing persecution, who should be using this time to focus on healing, to learn U.S. law to this degree. And so Brenda Perez is an organizer. I think she's now with Mi Gente, but she came and volunteered in Dili in 2016. And she kind of looked at the systems that the Pro Bono Project was using and developed this popular education tool. You can't quite see, so normally, so you would have, well, I'll just kind of explain them. So the idea here, you can see the list on the right-hand side. We have qué, quién, por qué, policía, en otro lugar. And those should there should be next to each finger. It should say one of those elements. So the idea is that it becomes a device for kind of memorizing these 5 elements. And it's a way of breaking down this into something that's a little bit more accessible. So we have this idea that the first element of an asylum claim is what? What was the harm that happened to somebody, or what was the threat? The second element is who caused the harm or who made the threat. The third element is why, and this is definitely one of the element that we kind of spend the most time talking about because it can be the most difficult. But why was the harm or the threat leveraged against you as an individual and not someone else? And so that can be a really kind of difficult conversation to have, but it's probably the hardest part, I think, of and like the most complicated part of the statute to kind of unwrap. So, you can see here it says on account of race, religion, nationality, membership in a particular social group or political opinion. So that's kind of what we're getting at when we're asking the question of why did they harm you or threaten you? For folks who are from other countries or who have family in other countries or other cultures, the way that we fixate on race in the United States, just as like a starting point for why this is not a culturally sensitive or necessarily a culturally relevant definition of refugee, is totally different from the way people talk about race in other countries, or to the degree people even have a conception of race in other countries. The fourth element is police or government. So would the police or the government of the home country or the country of origin have protected you from the threats or from the harm? And the last question is another place. Was there another place inside the country that you are fleeing where you could have lived safely? I'm going to pause there because I feel like I'm rambling a bit and don't have a great way to wrap this up. The kind of points that I'm skipping over or that we're not going to have time to get to. So we have this idea of knowing the law. And in addition to knowing kind of the elements of an asylum claim, we use this tool, this timeline, as a way to kind of explain the process. So we want people to understand the process. We want people to understand the elements of an asylum claim. And then we want people to also understand that the law, as it is applied in Atlanta, is totally rigged, that everyone is denied. And we start there so that people can kind of make informed decisions about how to engage with the legal process. The steps that I am not touching on today are using the law. And I guess to learn more about using the law, if you're interested in volunteering with the asylum clinics, we can have a training on kind of exactly how the volunteer teams work and how they help people to use the law. And then the last one is shaping the law, and that I think is a longer conversation and one that I don't have kind of enough answers to justify me like trying to lecture on that right now. But I'd be really, really interested in talking that through with folks, if there are folks on this call who have ideas on how we can transition from knowing and using the law to shaping the law. And with that, I'll kick it back over to Shelley, or I guess open it up for questions.
Yeah, let's, we have a couple minutes, so if folks have any questions about the presentation today. Ariel, if any of our I know right now with COVID, you guys have switched from in-person workshops to virtual, so if any of our attendees today are interested in participating in the workshop, should they just email you? What's the best way to go about doing that?
Yeah, I've put Alia and my email addresses up on the screen, so they can email either or both of us. Probably best to email both of us, and we'll follow up with a kind of a sign-up sheet.
I highly recommend. I did my first one last month. It's a really great experience, and then for law students, it's a great way to get that kind of client interface and kind of go through the process of getting all the information that you need and figuring out how to kind of get out their story and pull the information you would need for an asylum application. Does anyone have any questions for Ariel?
Hi, thanks for the presentation, Ariel. I was wondering if you could, I don't know if there's time or not, but speak to a little bit more about like the logistics or physicality of the asylum workshops and then how you've adapted that with COVID-19.
Sure. So we initially the workshops were held in a Quaker meeting house, and that was really great because it actually helped with a lot of the kind of community building aspect of the workshops. With COVID-19, we've transitioned to doing them entirely remotely, and so the way that we do that is we use kind of video conferencing to do kind of a huddle with all of the volunteers at the workshop. We'll then do breakout rooms. So we've divided the process into 3 parts, but 2 parts that occur on the day of the workshop. And so we'll have 2 teams, each responsible for one of those 2 parts. And we'll do breakout rooms with a kind of team lead in each breakout room. Kind of a quick huddle to figure out who we have on each team, what work needs to get done that day. And then folks mute the computers, turn the volume way down, and kind of call the people that they're going to be working with who are expecting the phone call at that point and have received. We have a YouTube video, kind of legal orientation, and some room to kind of talk on in a secret private Facebook group. And then the team leads will kind of stick around in the video conference space to kind of help troubleshoot any problems as they come up. Yeah, that's kind of the quickest summary I can give.
Awesome. Well, Ariel, this has been great. We're right at noon, so I'm going to have to sign off because COVID has led to a lot of um, Zoom and Blue Jean meetings for me. But I appreciate you taking the time to talk with us today. I did want to let folks know that today at 2 on the same link, um, Lynn Pearson, who's a senior staff attorney with us at Tahare, is going to be talking about immigration appeals. We have an appellate project here in Tahare, Atlanta, which focuses on changing the law, as Ariel alluded to, and really shaping, kind of pushing against this abysmal asylum granting rate that we have here in the Southeast. So I hope you all can join us then. Tomorrow at 11, same link, we're having Jenny Hernandez talk about an intro to crimmigration. And then tomorrow at 2, we have Eileen, we have Amy Hauer from Catholic Charities talking about public charge and family petitions. And then our final training for the series is on Monday with 3 social services managers from Tahare, GAIN, and from Kids in Need of Defense. So I hope most of you will be able to join us then. Thanks again, Ariel, and I hope folks think about volunteering for the clinics.
Thanks so much, Shelley. Appreciate it.
Yeah.
Thanks, everybody.